Hey guys, okay, so this is going to be a walkthrough of how I explain the agency documents. So this is going to be after you've already done your presentation and shown your value, you've gone through, the value proposition of what working with an agent, whether it be a buyer or a seller. So I'm literally just going to walk through the contracts paragraph by paragraph and what I would actually say. So let me share my screen. So we're going to find the forms. Most of our forms are found in the MLS. So we're going to come in here and you're going to click on Forms, Legacy Forms Library. And I'm going to come in here and we're looking for agency documents. So if I type in, so the seller one is the exclusive right to sell. So you can type in the word sell. These are going to be the most updated ones right now that we have from March 5th, 2024. So I'm going to add that over here. And then I'm also going to explain the buyer broker one. So we're going to, it's this one here, exclusive buyer broker agreement and agency disclosure, also updated March 5th, 2024. So we're going to click on that. And then we are going to create a packet just so you can see these. So basically how I explain these to the seller is I just say, okay, so this is going to be, you're going to put in the seller's name. This is going to be a contract that we're entering into between Keller Williams and myself as the realtor. So you can see your name auto-populates here. This would be the seller's name. And so the term of the listing is going to be, depending on how long you want this to be, you can choose. With sellers, depending on when I'm listing it, I would probably go 6 months and probably the same with the buyer. I have seen both of those be longer and I've seen both of those be shorter. So the thing to know here is that this is the ending date that we're going to put in here. So you will put your ending date. Let's just say it's 6 months out. So we'll just go October 17th. So just make sure that you realize this is the ending date. The property, so on a listing, this one is the listing. This needs to have the property address. So I would explain the term of our listing, Mr. Seller, is going to be until October 17th. It's going to be for your property that we have listed, the brokerage fee, and basically if you want to understand these paragraphs, but if you read the first sentence or two of this paragraph, it is going to explain to you what it means. So basically they're hiring Keller Williams and myself, and they're going to be hiring us for the cost is going to be, I put in $350, and this is for our admin fee or to pay your transaction coordinator, plus whatever you've negotiated with them. So I'm going to put 6% in here. On the seller's side, we definitely need them to know that the seller has negotiated a portion of the fee to be paid or advertised out to a buyer's agent. So this is going to be the amount that we're paying the buyer's agent. So if I've agreed to split it, then it would be 6% here and 3% is going to be paid out to the buyer's agent. Mind you, I've already done a presentation explaining why there's value in making sure that they are paying both the seller's agent and the buyer's agent. I do make sure that I explain to them that all commission is negotiable. So make sure that they really understand that. So this is going to be a negotiation conversation. Maybe they want to pay 5% here and they only want to pay 2% here, or maybe they're going to pay, 5%, they're going to pay 2% to you and 3% to the buyer. So this is all negotiable. So make sure that you really take time explaining that. Then you're going to have them sign right here. The next step is the protection period. I put 1 month. I've seen this longer. If you want, you can do 6 months, 3 months, whatever you want to put on there. So basically the protection period says that if we terminate or this listing expires and they happen to, a deal is done shortly after the termination of this listing agreement, we may be entitled to receiving a commission. If they hire another real estate agent, this would basically void that. So I just explained to them, it's literally just for 1 month after, and it just kind of covers anything that could happen in the next month as far as getting this home sold based on the marketing efforts of Keller Williams and myself as the agent. Seller warranties and disclosures. So I basically say the seller warrants to the company that you are who you say you are. So if they are signing on behalf of like a company or a trust or something like that, they do have the right to sign on behalf of those entities. Then I come down here and I explain agency relationships. So I do explain to them that there's a difference between a buyer's agent and a seller's agent. There's also could be a limited agent. So the way I explain it is I say, you know, I'm going to be your agent representing you. So I'm going to be the seller's agent representing you 110%. We've already negotiated and agreed to pay a buyer's agent who could potentially be bringing in a buyer, and they're going to represent their buyer 110%. If we get into a limited agency, this basically says that we are limited on what we can say or do because we be representing both parties. I also tell them that if this were to happen, there is another agreement that we would have to go over and that they would have to sign. So they absolutely will know if this is happening. The next section on professional advice. So I just say the company is true. Me and my company, we are here. We're trained to market and sell real estate. We are not trained in legal advice, tax advice. We're not attorneys. We're not accountants. We're not, we aren't home inspectors, anything like that. So I basically say outside of the realm of anything that has to do with marketing or selling the real estate, we do want you to seek outside professional advice. Dispute resolution. So I say if we were to get into a dispute over this agreement, we would first agree to go to mediation first, which is a process where we can have a third party help us come to a mutual agreement. If we cannot come to a mutual agreement, then we may end up in court. And I say the attorney fees are basically paid however it is resolved in court. So it could be that everybody splits the fees. It could be that the seller pays their own fees, the buyer pays their own fees. So it basically, whatever happens in court is how this is going to be paid out. Number 9, advertising and seller's authorization. So this just says the seller authorizes the company as well as us, the agent, to advertise the property for sale through printed, electronic media, basically anywhere that we see fit to get the home sold. We also have the right to disclose information on the MLS, the final terms. We also have the right to disclose on the MLS the square footage. We are going to find that information through potentially county records, any appraisals that we could find, any building plans that they have or that we find. So I like to mark all of these boxes and I just tell them, wherever I can find the information, I'm going to find the information. They also allow us to obtain financial information from the lender on the property. So that really is going to be like a mortgage payoff. We're also going to check title. So I let them know that, order preliminary title report on the property, just to make sure there's no other mortgages that we're unaware of or any other liens on the property. Number D actually says that we will obtain a key to the property. So right then and there, I will ask them, do you have an extra key that I can take? The key is going to go into an MLS or board approved security lockbox. So I really want to make them feel comfortable with the fact that we use secure lockboxes. Nobody can enter the property without a realtor, and all realtors are background and fingerprinted to get access to the key that's going to let them in. They are authorizing us to hold open houses on the property. They are authorizing us to put for sale signs, sold signs, anything like that, unless of course it is in like an HOA that doesn't allow that. Order the preliminary title report, order a home warranty if we want to. And then this one says that they do allow us to communicate with them for the purpose of soliciting real estate goods and services. So this is helpful if they're on like the do not call list or something. They are allowing us to communicate with them for the purpose of selling real estate. If we are to hold any earnest money, which typically we don't with a seller, but it can happen, we will place the earnest money in an interest-bearing account, and then we do basically donate those funds to UAR, which is creating affordable housing throughout the state. So if we put it in an interest-bearing account, we will donate the money. Personal property. So this does say that you are, Mr. Seller, you are responsible for your own personal belongings. So I do warn them, anything that can be picked up easily, anything of value, they want to pack it up and move it away because they are responsible for the personal property. Attachments, typically there are no attachments other than what is considered the agreement, which is the property condition disclosures, the data form, and the wire fraud disclosure, and along with this agreement is considered one agreement. For an investment in real estate, so this just says that the person who's transacting in this is not considered a foreign investor. They're not paying taxes to another country. So most of the time it is not. They are not considered a foreign person according to the IRS. Equal housing. So I just basically say we do not discriminate. We will comply with all federal, state, and local fair housing laws. Electronic transmission and counterparts. So this just says anything electronic that we do, including email, fax, signing through any kind of electronic signature program is okay. And counterparts are also okay. And so basically what a counterpart is if we were to send one document to a seller and to a husband and maybe the other document to a wife, and they sign 2 pages separately, but it's the exact same page, that's a counterpart. So it becomes one document. Due on sell clause. So I just let them know that certain types of transactions may consider what we call a due on sell clause, which typically means that the seller's mortgage may call the entire loan due, full and payable, if we participate in those kind of transactions. So most of those transactions are like a seller financing, a lease option, something like that the mortgage company may or may not like us to participate in. So it's the duty of the seller to make sure that if we do something like that, that their mortgage company will allow that to happen. The entire agreement, along with seller property condition disclosure, data form, wire fraud, any additional addendums we have here is considered one agreement and the entire agreement. And the effective date, it goes into effect the date that we all sign it, which would be the seller's signature and the real estate agent or broker's signature, dated, all of that. So that's when it goes into effect. The next form is the buyer agency form. So let's go over that. So again, just as a reminder, you've already displayed your value. You've already talked about your value. You've already showed the reason why they want to hire you, and they've agreed to do that. So this is basically saying that we're entering into an agreement between Keller Williams, the buyer, and us as the agent. And so again, this deadline is the ending date. So I would do it probably 6 months, can be longer, can be shorter. This really is up to you and the seller's time frame, but just remember it's the ending date. Here, when I'm talking to a buyer as far as the address, I will write TBD in the county because maybe I don't know if they're going to be in Salt Lake County or Utah County. Sometimes we cross over those lines. So I'll put to be determined in the county, or if I know, I'll just say they're purchasing in Salt Lake County. And the address, sometimes we don't have an exact address, so I will put in here to be determined. Most of the time and moving forward, you're not going to be showing any houses until you get them under this buyer broker agreement. So you will not know the address. Brokerage fee. So this again is the most important. We just want to make sure that they understand all commissions are negotiable. And so in here, we can tell them what we charge. So we charge $350 for a transaction fee or an admin fee. And then whatever you charge a buyer. So mine would be say that I charge buyers 3% to have me represent them. So basically what the rest of this says is that if the seller does not agree to pay that 3% and the $350 that I charge, that it is the responsibility of the buyer to make sure that they can cover that fee. So we do want to do our best to negotiate that with the seller, but we also want the buyer to make sure that they understand if we do not get that paid by the seller, the buyer has to pay that. They are responsible to pay it. So this basically goes into that, how they're going to pay it, what would cause them to have to pay it. And then you can see here, it also says in all capitals that it is negotiable and it is set, that it's not set by the Board of Realtors. This is between the buyer, the seller, and the company. Protection periods, so we would put in here, I usually put 1 month in here, so it just says that if they were to purchase a home after the termination or expiration of this agreement, due to things that I had been helping them with and they haven't entered into a contract with anyone else, we could be due a commission. Buyer's representation and disclosures, it just says that they have not signed anything with anybody else. They are not under an agreement with anybody else, and that they do agree to communicate with us. They basically are planning to move forward with purchasing a home. They're going to exercise their care and diligence, making sure that that they are going to do what they need to do to make sure that's the home that they want. Agency relationship. So I explain on this one that the duty of the buyer's agent, I'm representing you 110% your interests as a buyer. There will be a seller's agent involved that represents the seller 110%, and looking out for the seller's best interest. There is also what we call a limited agent, and that could be where we represent both parties. Therefore, we're very limited. We have to be neutral in the things that we say and the things that we do. I also like to remind them, if we were to get into this, then there is another agreement that we would have them sign. So they're absolutely going to know if we're representing both parties. Professional advice. So this again just says that we are trained to market and sell real estate. We are not licensed in any other profession like being a home inspector. We're not attorneys. We're not accountants. So if they have questions outside of our realm, we want to make sure that they seek professional advice. Dispute resolution. So this just says that if we get into any disputes regarding this agreement, that we will first go to mediation. It explains the mediation process is where we meet with a third party to come to a resolution before we actually hire attorneys and go to court. So this basically says attorney fees and governing law. So if we were to go to court, the attorney fees or any other costs will be, determined by the court. Whoever prevails in court is going to be the one who has to pay for that. So that it just outlines, like, it could be both parties, it could be one party. And so whatever happens in court is how that will be paid out. Buyer's authorization. So this just says that we will be disclosing some information and the buyer authorizes us to do that. We will be disclosing after closing to the MLS. We have to disclose on the MLS the final terms and sell price of the property. If there's any concessions paid, anything like that, we do have to put them on the MLS. It also states that we do put their earnest money into an interest-bearing trust account that is paid to the Utah Association of Realtors and donated to the UAR HOF to help people with affordable housing throughout the state. Attachments, typically there are no attachments, so I'm marking there are not. There could be additional terms if we're using an addendum attached to this, and then you would mark that there are. Most of the time there are not. Equal housing, so this just says that we comply with all federal, state, and local housing laws. Electronic transmission and counterparts are all okay, including email, faxes, electronic signatures, all of that is okay. Due on sell clause, so this is just like the seller side, so it basically says there's certain triggers that could, or certain transactions that could trigger a due on sell clause, which means the mortgage company could call the entire loan to be due in full. And we want to make sure that the seller understands that and is able to participate in that transaction. When you're working with a buyer and you're doing one of these transactions, we just want to make sure that that is going to be allowable by that property, by that mortgage person. The entire agreement, including everything else, the buyer due diligence checklist, the wire fraud checklist, those are all considered one agreement, and they go into effect the day that we all sign it, which would be the buyer's signature and the agent or the broker signing it, dating it. So those are the two biggest agency documents we have that are going to be having you be hired by either a seller or a buyer. So good luck out there.